Okay, my name's Geraldine Van Bueren. I'm the director of the Human Rights Collegium here at Queen Mary's. I've also headed a UNESCO project on law's duty to the poor, and we've set up the Human Rights Collegium to protect and do research into the rights of the vulnerable. Well, the human rights aspects really haven't been brought to the fore, and I think anything we can do to work with and assist the victims of Grenfell Tower is something we should do. So there are two things I'm going to be looking at tonight. Firstly, I think that the government is in breach of the Article 2 of the European Convention on Human Rights, a violation of the right to life, and that hasn't been looked at properly. And my purpose is doing that is not to have long court cases, but in addition to any criminal prosecutions, we could present a dossier to the government pointing out there's a very strong line of case law, and hopefully they would acknowledge their responsibility, apologise and make swift compensation. And secondly, I think we need to have a right to housing inquiry. So we can look at not only the Grenfell Tower aspects, but also housing generally. Not just to change the law, but also to the ethos, which needs changing in relation to social and public housing.
Right, our next speaker is Professor Geraldine Van Bueren of Queen Mary.
Thank you very much, and thank you Daniela, Tom and Nicole for organising this. Following on from Steve's comments, my name is Geraldine and I am a lawyer. And I want to do two things very briefly tonight. In addition to any criminal prosecutions that will be going on, I want to look at the cases that have been brought under the European Convention on Human Rights, under the right to life, which link the right to life and the right to housing. And the same provision is found in the Human Rights Act. And I want to do that not because I want a stream of cases going through, but because the case law is so strong that it points to the responsibility of the UK government in violation of Article 2 and the right to life. And that if this dossier of cases and arguments is presented to the government, hopefully the government would acknowledge, apologise and pay swift compensation to the Grenfell Tower victims and survivors so that they don't have to continually wait and go through the pain of more case law. The second thing is I would like to call for an inquiry into the need to have a right to adequate and safe housing in UK law. This is a right that is found in a number of constitutions, an increasing number of countries around the world, and I think it's time for the UK to incorporate such a right here. So firstly, let's look at the right to life. And the right to life is thought of popularly as a duty on a state not to kill anybody, and it certainly includes that. But there are also positive obligations involved in the right to life that are less well known, and it's these positive obligations that I think have great importance for those who survived the Grenfell Tower fire. Now, Article 2 of the European Convention on Human Rights says that everyone's right to life shall be protected by law. No one shall be deprived of their life intentionally. As I say, that's repeated in the Human Rights Act. And according to the European Court of Human Rights, there's a positive obligation on all governments to take all appropriate steps to safeguard life in the context of any activity. And this clearly applies to the laws, the policies and the regulations concerning Grenfell Tower. Specifically, the European Court of Human Rights has considered cases in relation to Turkey and Russia where there has unfortunately been a loss of life coming from housing. So the question that has to be asked is, are the principles which emerge from these cases applicable to the government and applicable to Grenfell Tower? In a case called Oni Yildiz and Turkey, the court placed much importance on the fact that the authorities knew from information in advance that there was a risk to life, in that case, from a collapse of a municipal rubbish tip. Similarly, with Grenfell Tower, the risks would have been to be made known to the government. We had the information to be considered would be the Lachenal inquiry in 2009, the information provided by the All-Party Parliamentary Fire Safety and Rescue Group, which was presented to the authorities before the refurbishment, as well as the information provided by the tenants themselves. And in the Turkish case, the court found that the timely installation of safety systems before the situation would have become fatal was very relevant. And they asked a very specific question. They said, would putting those safety systems being possible, quote, without diverting the state's resources to an excessive degree? So similarly, it would be open to courts here and the government to consider whether the installation of safer cladding, sprinkler systems, whether that would have diverted the UK resources to, quote, an excessive degree. And I think the answer is no, very clearly no. Another factor relied upon by the European Court of Human Rights was the lack of an effective supervisory system, and this would also be considered in relation to Grenfell Fire and the fire in safety inspections. A case brought in relation to Russia, where the court specifically said that there is less discretion in relation to governments where there is a risk of life, that the margin of appreciation is smaller. And under the European Convention on Human Rights, the government is responsible for all the actions of all its local authorities. And that's very clear. So in essence, the questions we have to focus on are what the government knew, what the government ought to have known from the knowledge communicated to it, and also critical is whether and how the government acted upon this knowledge. And as I say, the point of doing this is so that the victims don't have to go through and wait longer for inquiries and cases to go through the courts, but they can receive an apology, the acknowledgement, and compensation swiftly. Secondly, I want to look at the need for a right to housing inquiry. I think it's unlikely that that would take place within the existing inquiry. And if nationally it's refused by the government to have such an inquiry, it will be open to cities to host and hold such inquiries. This happened in the United States, in Madison County in Wisconsin. That the city recognized everyone had the right to housing and that the right to housing was a human right, even though it's not a right recognized by the US Bill of Rights. So there's a lot of scope here for local authorities to consider this issue. And I haven't plucked the right to adequate housing out of the air because the United Kingdom has been party for over 30 years to a treaty called the International Covenant on Economic, Social and Cultural Rights. And this in Article 11.1 enshrines a right to housing, a right to adequate housing. And the committee issues general comments which are of persuasive value, but which we could use to frame a housing inquiry. And under the Covenant, it's very clear that the right to housing is a right for everyone. It is not dependent upon income. And that housing is not to be regarded as a tradable commodity. In human rights terms, the question is, everyone, how can we be effectively and guarantee the right to everyone to adequate housing? And the committee, incidentally, which the United Kingdom every 5 years now gives evidence to this committee at the United Nations, it's a public submission of evidence, it's a public consideration of the questions, and anyone can go. And the Committee on Economic, Social and Cultural Rights has said, well, what does it mean, adequate housing? And there's great detail on this, but I just want to focus on the relevant parts in relation to Grenfell Tower. And they say, firstly, availability and accessibility. So there has to be access to emergency services. There has to be access to, and this would include fire alarms and all the safety systems. They look at habitability, and that includes, were there any structural hazards? Structural hazard would be a consideration of just one staircase down as the main fire escape route. They'd look at the adequacy of fire exits. There's cultural adequacy. When we're looking at fire access, do we actually consider larger families and cultural traditions in relation to that? They would look at accessibility. Has provision been made for those with disabilities, those who are slow because of age in relation to whether they're children or older persons to leave the building quickly in terms of if there were a fire? And all of this is found in the general comment. It's been published for a long time, and the World Health Organization has also issued principles in relation to housing and safety. And the UK, under the International Covenant on Economic, Social and Cultural Rights, is specifically directed to give priority to those who are vulnerable and in need. In other words, under the Covenant, social housing, public housing, becomes a priority rather than dropped to the bottom. So I would like for something to come out of this concrete, that consideration is made to thinking about exploring the possibilities of the European Convention on Human Rights and the right to life, and also to hold inquiries into this country to ask whether we now need a right to adequate and safe housing. Thank you very much.